and without notice, in a big secret. And it was only those commissioners who took that action that we're aiming this complaint at. We have named the commissioners who have sat since that time because it is our position that having denied these people payment, these commissioners have signed on, ratified the acts of their fellow criminals, or miscreants at least, and at the end of the day refused to release this money that has been collected. We're not suing the SEC. We're not suing the government.
Who in your analysis is the trustee of the funds? Who holds the funds?
There are actually several trustees who hold the funds, one of whom is currently the DTCC, and I only say that because I know the funds are on deposit at the DTCC.
Okay, spin that out for me, the acronym.
The Depository Trust Clearing Corporation. They are the clearinghouse for all of the financial transactions, basically, that take place in the United States.
Private or public?
It is a private company, but they act as a public one, unfortunately.
Well, as opposed to governmental.
It is not a governmental agency in the same sense that the Federal Reserve banks are not governmental.
What document governs the terms under which they hold those funds?
A trust agreement.
Between?
Between the people who originally set this up.
Who are?
One of whom was Bob Mayhew.
As an employee of the SEC?
Not as an employee of the SEC in any sense of the word. He was at one time on the board of directors of the company, right. CMKX. He never acted on behalf of the SEC.
What control does the SEC have over this trust fund?
They don't have any direct control over the trust fund. The agreement, however, that was originally entered into, as I understand the testimonial evidence that I've been able to accumulate without the opportunity to do actual discovery, my understanding is that Bob Mayhew and several of his associates entered into a deal first with the Department of Justice, and they got the SEC on board through the commissioner by talking to several of them. Primarily Christopher Cox, who was a defendant, a named defendant, he used to be the chairman. And the essence of the agreement they made was that in order to make this sting effective, the company would go and pump its stock up, which it did. The government would assist in that operation, which it did. There is evidence that they paid for some of the expenses associated with a car, a drag racing car that had CMKX painted on the outside of it, that was being very publicly bandied about the internet and raced in various jurisdictions. One of their ex-employees, a gentleman named Roger Glenn, who was an attorney, or used to be an attorney in New York, with the law firm of Angels and Edwards, signed on to increase the stock at the request of the SEC, I am told. And he came on to, or into CMKX during 2004. And from when he arrived there, the number of authorized shares of the company were of the order of either 1 or 200 billion, I forget exactly what. When he left some 9 or 10 months later, the authorized shares had illegally and improperly, and under every law that I'm aware of at least, had been raised to 800 billion shares. And this company eventually sold some 700 billion shares of stock. And there is over that many outstanding at the moment, 703 billion plus.
Why isn't your claim against the clearinghouse acting as trustee for these funds?
Because they are, that would be like suing the escrow company.
Yeah, but if the escrow company has the funds.
As I started to say, here's the simple answer, Your Honor. As I started to say a few minutes ago, and I probably did not finish. The original agreement, there was a war that ensued after the sting got under operation. Because what the sting always contemplated was that Mr. Mayhew would collect all of these bad doers, the hedge fund people and people like T.D. Waterhouse and all the other stock brokerage houses around who were naked shorting this company, collect them all in a big room, and offer them a deal for two reasons. First of all, to collect money for CMKX for what had been done to them, in effect. And second of all, to teach these people a lesson that there were people out there watching what was going on. And hopefully that would head them off from continuing in such illicit and illegal and improper behavior. That was in fact done. And I have a witness who was there when it was done. And they had a room about 3 times the size of your courtroom, in which they had representatives from all these brokerages from all over the world who were there present. They watched a video presentation because Mr. Mayhew, as the court may be aware, was at one time closely associated with the CIA, and Howard Hughes, and all kinds of other people.
I was going to ask you that, whether it was the same Robert Mayhew.
It is indeed the same one. The gentleman I happened to make acquaintanceship with in the 70s, I might say, to my good fortune. At any rate, all of these people were accumulated in this room. They were shown a video and a slide presentation of all of the evidence of their wrongdoing. And they were offered an opportunity. You can either step up and sign away your money and pay a reasonable amount for each transaction that you did illegally and improperly, or you can walk out of here and get prosecuted and go to jail because what you did is criminal. And every single person in that room stepped up and made a deal. After that time, there became a big conflict between the SEC commissioners and the other governmental entities who were supporting the SEC commissioners about who was going to have the right to release this money to the shareholders and when. And my understanding is it went on for some number of months, but ultimately the SEC commissioners prevailed and convinced Mr. Mayhew and his associates that it had to be their decision because only they and the rest of the government could determine when this sting had fulfilled its function. And that was the basis upon which he gave them the power to make this decision about when the money is to be released. And it's my understanding that every trust that is currently being held for release of this money is being held by a person who is sworn to observe that requirement, that the SEC, the U.S. government, whoever's going to make this payment, goes first. Since my information is that it was the SEC commissioners who had this power, that's why they are the defendants in this case.
Let's return to your Bivins theory. It's a taking.
It is. This money was supposed to have been released within a year of the time that the company was originally delisted in October of 2005. This is now almost October of 2010, some 4 years past that time. It is a taking only because they refuse, notwithstanding information that they have continued to give to various shareholders, they continue to refuse to release this money. If they don't release the money, then it's a taking, because they're preventing what is rightfully ours for us to receive. That's why it's a taking.
Thank you.
You're welcome.
Mr. Stout?
I have to admit that much of what I just heard, I've heard for the first time, because most of it wasn't cleverly explained.
I found it very educational.
Indeed. True or not, I don't know. But we're here to discuss what's in the complaint today. We're not here to give oral arguments and then testimony about facts that no one has any idea about, certainly not myself. We're here to talk about what's in the complaint, whether it's properly pled under Rule 8 of the Iqbal decision and under Formula. And as this court pointed out, in the tentative, it is not properly pled.
You know, I'm satisfied with that on the tentative. The best case for the plaintiff here would be to dismiss with leave to replead. I guess what I'm really interested in is whether this is a Bivins claim given the nature of the asset and whether